Companies Act Section 172. Penalty for non-compliance with provisions of this chapter. 1. Overview and purpose of the section. Section 172 of the Companies Act establishes the penalty framework applicable to companies and their officers in cases where there is a default in complying with any of the provisions set forth in this specific chapter of the Act. This section serves as a general penalty provision applicable in instances where no specific penalty or punishment has been explicitly provided for a particular non-compliance. The purpose of this section is to ensure adherence to corporate governance and regulatory requirements while enforcing accountability among corporate entities and their responsible officers. 2. Liability for non-compliance. Under this section, if a company fails to comply with any of the provisions outlined in the chapter and if no other section provides a specified penalty for the particular non-compliance, both the company and its officers responsible for the default shall be held accountable. The liability extends to every officer who is in default, ensuring that individuals in positions of authority within the company uphold their legal responsibilities and obligations. 3. Financial penalties imposed. In the event of a default, the following penalties shall be applicable. Initial penalty: the company, along with every officer in default, shall be subject to a penalty of 50,000 rupees, 50,000 Indian rupees. Continuing failure penalty: if the non-compliance continues beyond the initial penalty, an additional penalty of 500 rupees, 500 rupees, per day shall be imposed for each day that the failure continues. Maximum penalty limits. The maximum penalty that may be levied against a company shall not exceed 3 lakh rupees, 3 lakhs rupees. The maximum penalty applicable to an officer in default shall not exceed 1 lakh rupees, 1 lakh rupees. 4. Applicability of the penalty provisions. The penalty provisions under this section apply in the following scenarios. Failure to comply with any obligation mandated by the provisions of the relevant chapter of the Companies Act. Absence of any other specific penalty or punishment provision for a particular default. Instances where directors, key managerial personnel, KMP, or officers in charge of compliance have failed to fulfill their regulatory duties as stipulated in the Act. 5. Role of regulatory authorities in enforcement. The Registrar of Companies, ROC, and other designated regulatory bodies are responsible for ensuring compliance with the provisions of the Companies Act. If a company is found to be in default, the relevant authorities may issue notices demanding compliance within a specified time frame. Conduct investigations to determine the extent of non-compliance. Levy financial penalties as per the provisions of this section. Take legal action against officers in default if deemed necessary. 6. Impact of non-compliance on companies and officers. Non-compliance with the provisions of this chapter and subsequent penalties under Section 172 may have significant repercussions for both the company and its officers. Some of these consequences include: financial burden. The monetary penalties imposed may result in additional financial strain on the company, particularly in cases of prolonged non-compliance where daily penalties accumulate. Legal consequences. Officers who are in default may face legal scrutiny and potential disqualification from holding directorial or managerial positions in the future. Reputational damage. Persistent regulatory non-compliance may damage the company's reputation, affecting investor confidence, stakeholder trust, and overall business operations. Regulatory intervention. The ROC and other authorities may impose further restrictions, increased scrutiny, or take action to enforce compliance, which may hinder the company's operational flexibility. 7. Compliance measures to avoid penalties. To prevent default and avoid incurring penalties under Section 172, companies should adopt the following compliance measures. Establish a robust compliance framework. Companies should have well-defined internal compliance policies and mechanisms to ensure adherence to legal obligations. Regular monitoring and audits. Conducting internal audits and regulatory reviews can help identify any potential compliance gaps before they result in penalties. Training for officers and key personnel. Providing training sessions and awareness programs for directors, key managerial personnel, and officers can enhance understanding of legal obligations and best practices in corporate governance. Prompt reporting and documentation. Ensuring timely filing of returns, disclosures, and other mandatory documents with the Registrar of Companies can help avoid unnecessary penalties. Engagement with legal experts. Seeking guidance from legal and regulatory professionals can assist companies in interpreting and implementing provisions of the Companies Act effectively. For more details, contact us.